The first thing I should say is that I'm still a barrister engaged in acting for Dr. Haneef, and in fact I'm acting for him along with a couple of other barristers in the inquiry that's being conducted by Mr. Clark at the moment. So I'm not in a position where I can really express personal opinions with regard to aspects of the Haneef case. But what I can do is perhaps give you a summary of the submissions that were made on behalf of Dr. Haneef by me and Daryl Rangier and Nitra Kidson. And what one must remember about that is that they're just submissions, and ultimately the views with regard to whether they're right or not are matters that Mr. Clark himself has to decide. The events of Dr. Haneef's experience, of course, commenced as far as he was concerned on the 2nd of July 2007. The events in London and Glasgow had occurred on the 29th and the 30th of June, England time, and his baby had been born on the 26th of June, so about a week earlier, and had been admitted back to hospital after it had been released a couple of days after she was born. Dr. Haneef was going home to see his wife and baby when he was arrested at the airport on the 2nd of July. He was interviewed on the 3rd of July for a long period of time. A number of detention orders under the 2004 amendments to the Crimes Act under Part 1 Capital C were obtained, and he was in custody without charge and was questioned again on the 13th of July. So he's in custody without charge for 12 days, and he's arrested in the early, well, he was charged in the early hours of the 14th of July, 12 days after he'd been arrested. Bail was argued on that day. He was granted bail on the 16th of July, the Monday. A couple of hours later his visa was cancelled by Mr. Andrews, and he would have been taken into immigration custody if the sureties for the bail had been met. The case collapsed on the 27th of July, so 2 weeks later, and then he flew home at midnight of Saturday, the 28th of July. They're the events in short. Since then, the cancellation of the visa has been set aside by the full federal court, and that's been accepted by the current immigration minister, and the inquiry is looking at all of those things. But what we did in the submissions is we analysed each step in the process. We analysed the situation, the information that was available at the time of the arrest. We analysed the information that was available after the first record of interview. We analysed information available and recorded in a document by a police officer, Mr. Sims, when he was making a further application for detention on the 11th of July. We looked at the situation just before the second record of interview and the information that seemed to be available at the time of the arrest. We looked at the circumstances of the submissions made at the bail application, and we looked at also the information that was provided to the Minister with regard to the cancellation of the visa. Probably I'll just make a couple of short points which come out of the submissions. The first thing is that we were really startled by not only the factual errors that were contained in the material that is now available to us or became available to us at the time, but also the information that's not contained in any of the relevant documents which were produced by police officers or others at that time. And one of the obvious errors was the statement that was made during the bail application that the SIM card of Dr. Haneef, which he gave to his cousin Sabeel, was found in the burning Jeep at Glasgow Airport, and that wasn't corrected until the ABC broke the story about a week later. He was actually found on Sabeel, 300 kilometres away in Liverpool, when he was arrested. So that's one of the obvious errors that is known to everybody. But when we looked at the documentation a lot more closely and had the time to do that for the submissions, we discovered other errors and omissions which were probably even more startling in a way. For example, it was the police officers knew, because they actually confirmed it during the interview, that Dr. Haneef was trying to ring somebody, a Mr. Webster, who it seems was an investigator from London who were asking him questions. He was trying to ring him on the afternoon that he was booking the ticket to go home, and the police officers from the mobile phone had the fact that he had rung on 3 separate occasions, and a little bit later again on the 4th occasion, that he didn't get through on any occasion. But that was never provided in any of the documents. It's not contained in the Part A document that was provided to the Minister. It's not contained in the material that was placed before Mr. Gordon, the magistrate who was considering the orders. So that seemed, and we've made the point in the submissions, to be an extraordinary omission. And in more recent times we now know about the email that the terrorist, Kafil, sent to his brother Sabeel, who the judge found at the sentencing hearing recently was not a terrorist and was not involved in the plot. That email showed that Sabeel was not involved in any terrorist group, and that just doesn't appear anywhere in the information that we've seen, so we don't know why that is another omission. So that's probably the first point I'd make, is that the factual errors and the omissions from the factual material as it was presented to different agencies, including courts, that they're quite astonishing errors and omissions, and that's the point that we've made to Mr. Clark with regard to that. The other thing which I would say, and we've made this clear in the submissions as well, is that at the time we thought that the cancellation of the visa was sort of a panic response to the fact that Dr. Haneef was about to get bail. But when you get the documents on FOI, particularly from the AFP but also from the Immigration Department, what you realise is that these options were always being considered, and even in documentation as early as a couple of days after Dr. Haneef was arrested, you see the fact that they were looking at preventive detention orders under the later amendments to the Crimes Act, the terrorism amendments. They were looking at control orders. They were looking at whether they could charge him or not, and they didn't think they probably could. And the thing that you noticed with regard to all of these law enforcement options was that the problem was there wasn't enough evidence, in the opinion of the police officers whose opinions were being expressed, to use those. Not enough evidence to seek a preventive detention order, not enough evidence to seek a control order, and they were pretty unsure about whether he could be charged, whether there was enough evidence for that. And it seems that the cancellation of the visa was considered along those, and it seems that it wasn't to be used until the law enforcement options had expired. But it seems that the great advantage it had was you didn't need much evidence for it. That shouldn't be right. You should need a huge amount of very, very satisfactory evidence to convince a Minister of the Crown that he should cancel somebody's visa and exclude him from the country, especially when he's a doctor pursuing his studies. So that's the other point that I would make out of the 125 pages of the submissions, is that it was always considered as an option to cancel a visa, and the big advantage seems to have been that the evidentiary requirements with regard to convincing the Minister were much less stringent as far as the police officers were concerned than the evidentiary requirements with regard to the other matters like the preventive detention orders. So that's the highlights of the submissions that Dr. Haneef's lawyers have made to the Clark Inquiry. The submission runs to 125 pages, and it's now actually available on Mr. Clark's website, which you can access through going through the Commonwealth Attorney General's office. So any of your viewers can look at the submission in all of its beautiful 125 pages and not just take my little summary of it as a given and as being a correct summary.